Good morning. In our continued series on the discussion on land tenure systems, I want us today to look at another important area with regard to land, and this is land ownership methods. In other words, how do we own land? How do we utilize land? So this is the discussion that I want us to have. There are, of course, several methods of owning land, and these are the ones that I want us to look into moving forward. One of the most common methods that we use to own land or to acquire land is what we call the customary rights. Customary rights to land largely happen among indigenous societies where land is passed over from one set of owners to another set of owners, largely through inheritance. So customary rights to land are usually created following their traditions and also through the ways in which community leaders assign land use rights to community members. We have lands, for instance, that are collectively owned by communities. And these lands, such communities define how one gets to acquire and use such lands. If you go to most of the pastoralist communities, land is communally owned, and rights to individuals in terms of how they use land is clearly defined. So elders, who are normally the custodians of such land, define who can use land, where, and how long. They also define what can be used on that land and what cannot be used on that land. And these rights are generally agreed upon by members of the community, and also they can also be used in a court of law to defend any position that has been taken by the community. And these rights, they have origin in the way land has been used in a given society for a very long period of time. For instance, most of the ancestral lands, communities have used them for centuries and centuries. And the experiences in terms of their use have been appreciated and over the years passed over from one generation to another. And that way, people are able to use and access land. And in many cases, it is done so much harmoniously. Again, we also need to notice that some of the community rights or other customary rights have been codified and also recognized by modern state laws. For instance, in Kenya, we have what we call community land, and the Community Land Act, I think Act 2016, specifies how and rather recognizes that communities can own land collectively. And it also sets up committees that are often utilized to manage such pieces of land. So customary rights remains one of the most fundamental ways or methods of owning land. The other method of owning land is what they call inheritance. And inheritance is simply the practice of passing on private property, such as land, to another person upon the death of the owner. And here is a person who is entitled to receive or inherit property of the dead person subject to the applicable rules of inheritance. A person does not become an heir before the death of the deceased, since the exact identity of the persons entitled to inherit is determined only by the person or rather it's only determined when the person passes on. And inherited rules can be patrilineal inheritance, meaning that only sons or only male children inherit land, or it can be matrilineal, whereby only female children inherit land, or it can be egalitarian, which implies that land can be inherited by both sets of children, regardless of their gender. So most cases, again, in our cultures, we pass over land to our children, and the children have the right to inherit the land that we own. Many cases, again, private land. Sometimes you must consult your children if you want to sell it or a portion of it, especially because of the fact that the law does not permit landowners to sell land without regard to the future of the apparent heir. So in that case, they have to be consulted. So inheritance remains an important and a major, the most common method of owning land, especially in Kenya and especially in many societies around the world. The other method of owning land is called leasing. And when you talk of leasing, we refer to a process by which individuals access and utilize land for a given period of time. The lessor is the person that owns the land, or the legal owner of the land or the asset, while the lessee is the person who is given the right to use the land after some time, upon which the land reverts to the lessor. In many cases, it is done through certain payments, or it might be given free for a given period of time. Now, there must be very, very clear arrangements in terms of how this thing works, so that the person who receives the land through the process of leasing, that's the lessee, agrees to abide by various conditions regarding the use of land. For instance, they might agree that the land that is owned, no permanent buildings should be constructed. If that's a condition, then the lessee has to agree with that. The land that is owned might also imply that no commercial trees should be planted, or crops that require several years to mature, such as tea, coffee, among others. So there has to be a very clear arrangement on how that land is used. So there must be conditions that the lessor sets out and for which the lessee must agree to abide by. Now, there are various terms or periods upon which the lease agreement might be, so that we have what we call a fixed term lease, which implies that the person uses the land for a given period of time, after which, when it runs out, he or she surrenders the land to the owner. For example, land could be leased maybe for a fixed period of 10 years. Then, upon the expiry of the 10 years, then the person returns the land to the original owner and no longer uses it. Or we can have what we call a periodic tenancy. This one is when the land is used for some time, which is then determined by the two parties. Again, this can be subject to extension or renewal of the lease. You might say that maybe you want to use the land for 5 years, and then after 5 years, another renewal of either another 5 years or a lesser period or a longer period. That's what we mean by a periodic tenancy. Then we also have what we call the tenancy at will. The tenancy at will means that either party may terminate at any time by giving reasonable notice. What does that mean? What it means is that if, say, you are farming say maize in the farm, or rather the land was used for purposes of farming maize. And then the tenant, rather the landowner, the landlord might decide that once the harvest is made, then he or she stops. It gives a notice to the lessee so that no further activity on the land is carried out. That's what we mean by tenancy at will, meaning any party can give a notice to terminate the lease. Then we have what we call the tenancy at sufferance. This one exists when a tenant remains in possession of a property after the expiration of a lease. A lease probably was for maybe a fixed period of 10 years, and the 10 years have expired. But again, the owner of the land has still allowed the tenant to continue utilizing the land. In that case, the term of agreement in that matter, or the type of lease understanding that matter, is what we call the tenancy at sufferance. Another important method that is often used, of course not so much, but in some cases it is what we call adverse possession. An adverse possession is the legal process whereby an owner, occupant of a piece of land, gains it after a certain period of time. That is, you are using a given land which originally was not yours, and there was no contract in terms of lease of how long the person uses the land. And then the person continues to utilize the land without the landowner coming up and complaining that his or her land has been encroached. After some period of time, the person can claim ownership of that land. In most of the jurisdictions, adverse possession occurs after 12 years of continuous use of land. So that if you use land for a continuous period of 10 years, then after 12 years, if the owner never complained and you developed the land, built permanent structures, paid rates that are required, and met all the conditions that are required, then you can apply to the relevant agencies, land agencies, so that you possess that land or you acquire that land through what we call adverse possession. But it's also important to note that to successfully claim land under adverse possession, the claimant, that's the person asking to be granted the opportunity to own the land, must demonstrate that his or her occupation of the land meets certain conditions. One of them are the following. Number one, continuous use of land. And I said continuous in this case. In most cases, it is normally the 12 years. So if you have used a given piece of land continuously for 12 years, uninterrupted, and without the owner claiming or asking you to vacate, then that's one condition that you must meet. The second one is non-existence of agreement or license for occupation of the land. In other words, there is no agreement or license between the user and the purported landowner. Otherwise, if there's an agreement, then that cannot qualify, because an agreement would mean that it is land being used under a lease agreement. So there must be that. Then you must also show that possession of the property is obvious to anyone who observes it. So that if you had put up structures, then it is clear that, and you can prove that you are actually the one that developed that structure. And you can have witnesses that can prove that indeed you are the one who developed the structure through your effort and through your resources. Then the other one is actively possess the property, including maintaining the land and paying taxes and exclusive use of that land. Depending on where land is, there are places where landowners are required to pay land rates. So if you're in a place where you are the one paying the land rates and any other taxes that apply to land, and you have done so continuously for 10 years, or rather for 12 years, then that grants you or enhances your chances of possessing that land if you make a formal application to that end. The other important method, which is largely used in the agricultural communities, is what we call sharecropping. And sharecropping is normally an arrangement with regard to agricultural land in which a landowner allows a person, who in this case we call the tenant, to use the land in return for a share of the crops produced on that land. This method of access to land has the benefits and costs to the owner and also to the tenant. What are some of these? The landowner encourages the cropper to remain on the land, solving the harvests and other problems. Since the tenant pays in shares harvest, owners and croppers both share the risks and benefits of harvests, being large or small, and of prices being high or low. What we basically mean here is that we have instances in which landowners might grant opportunity to a person in need of land to till the land, maybe 20 acres, and then the crops that are harvested from that land is shared at an agreed proportion. Maybe the landowner takes 20% of the crop share of the harvests, and the tenant, the person tilling the land, takes the 80%. That agreement must be laid bare before the utilization of land begins. So this is also another method that has been used severally in many communities and in many societies and in different parts of the world, especially among the agricultural communities. So these are some of the methods that can be used to acquire land. Thank you so much for your time.